All right, our next case on the docket is 128-881 Sampat versus the Department of Children and Families and Joshua Stone.
Joshanna.
Council enter their appearances for the appellant.
For the appellant, Dr. Pravin Sampat, Pamplona Flores Jr.
And do you wish to reserve time for rebuttal?
I would like to reserve 3 minutes.
3 minutes, you've got it. And for the applicant,
Good morning, Your Honors. Mark Altenburn, General Counsel for the Kansas Department of Children and Family Vocational Rehab, and Joshanna Stone.
all right, thank you. You may proceed, counsel.
May it please the court. This case is one in which the district court, as the court is aware, denied or granted a motion for summary judgment, basically for two reasons. One, both of them related to the sufficiency of the evidence to support a prima facie case of discrimination, applying the Beach decision from the Supreme Court, which in our view has really no application to the case at hand. The Beach case was a reduction in force case, and it was appealed after a trial to the court, where the court made specific findings of fact and conclusions of law, and was subject to a different standard of review than the case before the court today. Today, we're here to determine whether or not, as the court I'm sure knows, that the evidence that was presented on behalf of the plaintiff in this case, in the light most favorable to him, presented a prima facie case of discrimination. The court required us to show that the position from which my client was terminated was filled by a non-protected group member in order to establish a prima facie case. That is not the law. As pointed out in my brief and set forth in the 10th Circuit decision of Kendrick versus Penske, the court noted that there is a line of cases that says that that is one way in which a plaintiff can establish a prima facie case, but it is at best language that is dicta and not a requirement of the court.
But the Beach aircraft case uses the four elements, and one of those elements, I think it's the fourth element, says that was replaced with somebody that was not in protected. How is that the language was qualified for the position? That sort of thing.
And a non-protected group member,
Yeah.
yes. That is true. That is what Beach says. But that Beach also acknowledges that there are other ways through which a plaintiff can establish a prima facie case of discrimination. In this case, and the general rules with regard to these cases, starting with McDonnell Douglas and following through Burdine and Martin versus Nanny and the newborns and the other federal court decisions upon which this area of the law evolved, all suggest that and state that what we're really looking for in a prima facie case is whether or not you're a member of a protected class, whether you suffered adverse employment action, and whether or not the evidence, whatever your evidence be it replaced by another person or some other direct evidence, has a tendency to establish an inference of racial or other discrimination against the individual. And in this case, it is uncontroverted that my client's position was not filled until after what would have been the statute of limitations on his claim under the Kansas Act would have expired. That is, it was filled in August of 2022 when this case was had to be filed by late November of 2021.
What does that show us? What is that fact? What is the significance legally of that fact?
Well, what it demonstrates is the ability of an employer, and in this case, the state of Kansas, to bypass or engage in unlawful discrimination by simply waiting to fill a position until the time has expired for a plaintiff to pursue their claim. Then they fill the position and say, if you lose because it wasn't filled during the time that you had to file.
Is there a burden to show that it was done with that intent?
No, I don't believe so.
We just are to infer it because of the facts that
We
there was a period of time that it wasn't filled.
we infer it because the position remained open and accepting of applications for the position continued.
Sometimes the state moves slowly.
That is very true. But we're only talking about an inference of discrimination. We're talking about the first step towards establishing the claim. This is just the first prong of a three-pronged test that the plaintiff would have to establish in order to show that he was the victim of unlawful discrimination. We're not talking about the ultimate burden at trial. This is supposed to be an easy step to determine whether or not there is some evidence to suggest that the plaintiff was discriminated against. And in this case, what we have is, and this goes to the issue of disqualification, which was the other issue that the court relied upon, the absence of any evidence to suggest that he had anything other than above standard or exemplary performance during his entire tenure from June of 2015 through December of 2019.
There was some question about that.
There is question about that. The question was Ms. Stone's affidavit and the other supervisor's affidavit that said he had poor performance. There was no documentation, no written documentation of oral counseling, no written documentation of any kind of disciplinary action or counseling, nothing in the record. And my client's testimony was that he hadn't been disciplined or talked to about any poor performance.
And
When this,
the first indication that he had, and you can correct me if I'm wrong, was the same year that he had a positive. Like earlier that year, he had a positive review.
correct. In January of 2019, the former director, Dr. George Stern, evaluated his performance as above standard or excellent in all areas. Within a month of that, Ms. Stone was hired and put him on a performance review, reviewed some cases of his, and he heard nothing back from that. Not that he was doing a good job, a bad job, or an average job. And so we are to infer at this stage of the proceeding that there was nothing lacking in his performance because of the evaluation that he had received within 30 days of that. And so when you get through the year and you come to December, and during that period of time, the same person who did a performance review of him changes the terms and conditions of his employment by assigning him different cases that he was assigned to than he was assigned to before, treating him differently than other doctors who were performing medical reviews. There's an inference that comes up of discrimination against him. And that's all we need to establish at the prima facie stage is an inference of discrimination. Then the employer has to come forward with their legitimate non-discriminatory reason, which would be the poor performance issue. That is a question of fact. That is in dispute. Even if we don't include Dr. Griffith's affidavit, which we believe should be included because under 6219, it was based upon her stated personal knowledge. She defined how she had personal knowledge of the facts that she'd made in the affidavit, where she testified and said that Dr. Sampat was treated differently than the other non-Asian, non-protected group doctors in the office.
Counsel, is there a question about the timeliness of your client's appeal?
No,
Everything's been done timely?
I don't believe was ever an issue raised about its timeliness. I believe the question, I'm not sure where that question might arise. It may arise in the issues with regard to the federal case that was.
Yeah, the federal case?
The federal case that was filed, that it was dismissed, and this case was commenced and served within the 6
Within the
months.
time frame.
Yes.
Very good.
But that raises the other issue, which would be I believe the third issue in this case, whether or not Judge Christopher rightfully dismissed those federal claims
And
as
whether
res
you timely
judicata.
appealed that,
Excuse me?
and whether you timely appealed that, that's where the time.
That's where the time
comes in.
question comes in.
Before we get into that, can I go back for a minute? Because this whole idea that the individual was replaced by a person outside the protected group. Is that kind of a unique rule in Kansas or? I mean, I hadn't seen that before, but I've been out of practice for quite a while, but I think what I hear you saying is the statute doesn't make this requirement. This is one case that says these are 4 things to look at. And when you say it's really more like dicta, what you're saying is these are 4 things that were considered in Beach, but these 4 things are not part of the statute. They're just things that the court is saying, these were things you could look at to make a determination that discrimination has taken place. Is that how I understand your argument?
That is absolutely correct.
Right, because this language doesn't appear anywhere in the statute.
That's
This is
correct.
just the court opining. But
this
this
is one
isn't a
way.
hard and fast rule.
Right.
Is what you're saying.
Correct.
Okay, I just
And-
want to make,
And that was further recognized in my argument with regard to the failure to inform of the performance issues was further recognized in another unpublished opinion that I discovered this week. Matisse versus the City of Stafford, Court of Appeals decision filed August 2nd, 2024.
and so you believe there's a factual issue because they never documented that his performance was poor. There's no documentation and you have an affidavit from somebody that says he was treated differently and his performance was good. So that creates the factual issue that should allow the case to go forward.
At least to the next
Past
step.
summary judgment at least.
Yes.
Okay, I just want to make sure I'm understanding this.
That is absolutely correct in terms of what we're contending in this case. Now, getting back to that race judicata issue for a moment.
The federal case.
The federal
Yes,
case.
I do what you-
Judge Christopher raised that on her own sua sponte in terms of, I don't believe the state had indicated that they believed or agreed that there was race judicata applicable to those decisions or the
But
decision.
the issue is she made that decision well before this summary judgment decision, and the summary judgment motion didn't have anything to do with the dismissal of the federal claim.
Correct.
So and did you file a reply brief
I did not.
responding to that jurisdiction issue?
No, I did not.
Okay, thank you.
I just asserted it in I had no new argument to make other than what I had.
Oh, I'm
in
sorry.
my-
You asserted it in your
Opening brief.
appellate opening brief? Okay,
Yes,
I was
that it-
thinking that they had just raised it in their appellate brief, but okay.
Because under 6241, the dismissal, voluntary dismissal is not on the merits. It's by statute that it's not on the merits, and so it couldn't be res judicata or issue preclusion,
Okay.
which is what Judge Christopher found. And that was,
Right, but I think we're talking 2 different things. She said that was the reason she dismissed the federal claim.
yes,
The jurisdiction issue that I'm asking if you raised in your opening brief was because you didn't, that wasn't part of your notice to appeal. So your notice to appeal didn't include the dismissal of and was that just, because I think they talk about that, the appellee talks about that. Did you talk about that I don't have the briefs here to look.
that specific point about it not being raised in the notice of
Of
appeal,
appeal.
I don't believe was included in my opening brief. It was addressed, I believe, in the docketing statement, and it was reserved in the docketing statement. And
Okay. But they raised it in their brief.
yes,
Okay, and you didn't reply.
I did not reply.
Okay, thank you.
Thank you, Counsel.
Thank you.
You still have your rebuttal time.
Yeah. So will you answer that my same question for me? These 4 factors from breach, or it was that beach, not breach, beach, not breach. Is that hard and fast black letter law that those are the four things you have to have? Or was this just a court saying, these are four things that you could, I mean, if the court did say that, they pulled it out of thin
Well,
air because it's not in the statute.
the Kansas Supreme Court in Beach, under facts like this one, where you're dealing with an individual who is terminated from a position. And it's important because these discrimination cases can have different types of facts that change the elements a bit.
Right.
That's why Beach is important, because it specifically addresses the facts in this case where somebody was terminated. And those four elements given by the Kansas Supreme Court, that is the prima facie cause of action in Kansas for termination cases under these two statutes. Now, the Kansas Supreme Court, if you were to look back, and I laid this out in my brief in an attempt to provide some understanding where that came from based on counsel's argument, they took these elements from a Kansas appellate court that utilized these same four elements in this type of cause of action. They took those elements from a federal court case, again, using the same facts as this case. So that's how it progressed. And in all three of those cases, it wasn't an either or. Are we going to use all four elements? Or are we going to use some of the elements? Counsel makes the argument in his brief that because the Beach Court used the word, you may prove a prima facie case by using these four elements, that somehow made the four elements optional.
How should we treat this precedent then? Is it binding upon us, or are these suggestions by the Supreme Court that if you have this, you've got a prima facie case? Well, how are we to deal with that?
The
It's
Beach,
exclusive.
the Beach decision we submit is absolutely binding on this court. It's a Kansas Supreme Court case dealing with the facts of this case under these two statutes. So in that respect, these aren't optional elements. The court, there's nothing in this decision that makes these elements optional.
But
They're required.
in every case, these
In
four are-
cases under these two statutes
For termination?
for termination, which is distinct because not all employment discrimination cases
Right.
carry the same facts. Some you have a failure to hire, some you have a failure to promote, so there's different factors and they use different elements based upon what those are. This is also very specific to the Kansas statutes. Judge Christopher, for example, counsel didn't file a complaint with these two statutes. Judge Christopher, in addition to her sua sponte dismissing on the basis of res judicata, which we did not argue, by the way, also said, hey, let's see if you can file something under these facts.
Because I'm going to throw it out under this. I'm going to give you an opportunity to amend, to add.
Right. So
That's when they added the two statutory claims.
that's correct, pursuant to her suggestion.
Mhm.
So the Beach case is directly on point. And in that respect, it's a Kansas Supreme Court case. There's no cases out there that question it. There's no yellow flags. It's on point. Counsel's argument that these elements are optional. The four elements are element 1, 2, 3, and 4. I mean, that's how it's phrased. So all four are required. It is undisputed that Mr. Sampat or Dr. Sampat was not replaced by anybody. It wasn't just somebody from an upper.
How do you respond to Mr. Flory's argument, though, that, well, isn't that convenient? Because then an employer can avoid a discrimination case by just keeping the position open until the statute of limitations runs.
Well, it's a novel argument. It's an argument he didn't make in his brief. He's making it for the first
Okay.
time today.
Yeah.
It's an argument that I don't think makes a lot of sense. I can tell you as somebody who's worked at DCF for 6 years, if we have a position open that needs to be filled, we fill it. The facts of this case, as testified to by Joshanna Stone and her supervisor in the affidavits, there was a period of time where all the files were reduced. There wasn't as much of a workload. So Dr. Sampat's primary argument is he had a reduced file number. And nobody else did,
Right,
although he
which
testified that
and
he has,
made less money.
right, although,
Wasn't it that he was given cases that actually were that had more information in them? And
Took more time.
took more time.
Yes,
And then
he
he wasn't
offered,
given given as many of the easy, in quotes, easy cases.
yes, he argues that he was given different kinds of files than the other consultants and fewer files than the other consultants. Of course, at his deposition, he testified he has no idea what any of the other consultants were receiving. So, which is one reason why the district court judge said, your testimony can't save this motion for summary judgment because you yourself admit you don't have any idea what anybody else was doing. And this goes to Dr. Griffith's affidavit and subsequent testimony, because they attached the affidavit to the response to the motion for summary judgment, whereby she offers testimony about the files and the number and the types, although she doesn't provide any foundation as to where that information came from. And this is a motion for summary judgment. This isn't a motion to dismiss. So the evidentiary requirements are different. They have to submit evidence that is admissible, and we've put that in our brief, that is admissible at trial. So the court said, and we actually came back and the judge reopened discovery at that point to allow for us to depose the affiants. So I deposed Dr. Griffith, and her testimony I've placed in the brief. She testified she has no idea what she doesn't know what Dr. Sampat was doing. She didn't know what the other consultants were doing. She thinks she might have received that information from Dr. Sampat himself. And then we get text messages that basically confirm that. There's a conversation between two of them. Dr. Sampat reaches out, says, did you notice I'm getting fewer files? I'm getting different files. I mean, so Dr. Griffith stated, I have no clue where any of this information is coming from. It's also important to know, counsel criticizes the affidavits of the DCF employees. No depositions were taken of them. Nothing was done with respect to their affidavits. They were left to sit there, even though the court reopened discovery on that. So
his claim is that he's being treated differently than other employees in his position because of the protected class, but he was able to present no evidence to avoid summary judgment that there was anybody treated better,
correct.
Basically.
Correct. I mean, we're talking about the third and fourth elements of the prima facie case set forth by Beach. The third one is not replaced.
Is that fatal? Do we even need to get to this? To me, is crazy. Somebody's been replaced. That factor number 3,
Right.
which really seems very bizarre to me. But I mean, I see it could be it could be a factor, but a mandatory factor. But anyway, so is the fact that he wasn't able to show that he was being treated any differently, is that the game changer right there?
Well, I mean, the overarching argument of any discrimination case, right, is disparate treatment.
Right.
Every case you look at, federal court, state court, disparate treatment, that implies that he's being treated differently than others because
Right.
of his race. Or
And the
faith.
fact that he could not present any evidence, is that alone enough?
I would say it's alone enough in the sense that element 4 requires that he present some evidence, admissible evidence, that he was qualified for the job in light of testimony given by the defendants. Now,
Well, isn't the
Well,
heart
wait,
of
he
these claims that they have to show that the membership in the class made the difference?
yes,
That's
precisely.
the essence of what has to be done.
precisely. That is precisely the point. Under these statutes, at the end of the day, when we cut through everything, the plaintiff has the burden of proof that he was terminated because of, in this case, his race and or age. He has provided zero evidence of that.
There's adverse action here. He was terminated. And you stipulate that he's a member of the
Oh, certainly.
class. So the only thing that you're concerning is that whether he was qualified for the position, was he qualified for
Oh,
the
he was
position?
qualified.
Are you stipulating that he was qualified?
No. One of our arguments, arguments 3 and 4, argument 4 is qualification. At the time he was terminated, he wasn't qualified for he was terminated because of job performance.
Well, that's a
So,
little bit of a stretch, isn't it? I mean, it's qualified, then that would be everybody. Why is that a separate factor? Because if you're terminating somebody for poor performance, then you've met factor 4. That can't be what factor 4 means.
Well,
Means he was, when he got the position and held the position, he had the requisite training and experience to do the position.
sure.
Whether he did it properly or whether others were treated differently but doesn't this factor just mean I was qualified for the position and I was treated differently? I mean,
I mean, ultimately.
seems like a stretch to say qualified means you're not qualified if you're not doing the job well.
We can, I mean, we can disagree on that, and that's fine. The point is, there's no evidence he was terminated due to his race or age. Dr. Sampat argues he was terminated. Therefore, it's because of race and age. He provided no evidence as to what was happening to anybody else. In fact, he admitted at his deposition, he doesn't know what any of the other consultants were doing. He doesn't know if any of the other consultants have been fired. He doesn't know anything about any of the other consultants. Dr. Griffith at her deposition agreed with that. She didn't know either.
Right. I'm not doubting that.
Yeah.
I'm just saying, is that enough? That he didn't present any evidence that he was treated any differently?
Well, if this court decides that he's made it past his prima facie, which means this court.
Well, what I'm saying is that is absolutely the single most important thing that he's got to, if he doesn't have any evidence on that, he's out of it.
Yes, because under the shifting process.
And do you even need to get to these other things is what
Well,
I'm
you have
trying
to
say.
because that comes first.
Okay, so you're saying Beach says you have to.
Beach said. Yeah,
But if we say Beach doesn't say you have to, it's just.
right, the McDonnell Douglas shifting burden, the plaintiff has the burden of providing a prima facie case, evidence to support the four elements. We assert he doesn't get there.
Okay.
But even if he does, then you have to get to the second point where we provided an argument that he was terminated for reasons other than race or age. Well, there is no evidence that he was terminated for race. The plaintiff himself can't even give evidence that he was terminated for race or age.
I'm going back to Beach again.
Sure.
It seems to me, when I read Beach, it says that if you have evidence of this, there's a presumption involved.
Mhm.
And if you don't have elements of all, you're not entitled to the presumption. Isn't that basically it?
Our position is the analysis ends with Beach. Beach lays out the four elements that the plaintiff has the burden of proving to start the whole analysis. And one of those necessary elements, he was replaced by somebody in the upper 10th class. It's undisputed he wasn't. Now they're arguing that we did this purposefully to avoid the statute of limitations. There's zero evidence of that. That question wasn't even asked by anybody, including counsel for Dr. Sampat.
Was there evidence of it? Was he replaced
No.
by anybody?
By anybody. It remained vacant for over 2.5, almost 3 years.
What year I'm trying to find what year Beach was decided.
I've got it here, Judge. It's 1993.
So
Still
way
vacant.
before our Supreme Court started into this.
I don't know if it's vacant to this day.
Statute and only the statute, and we're not going to read anything into the statute that isn't in the statute. I mean, they've certainly held that a lot since 1993. But anyway, as you can tell, I'm personally, I have some problems with Beach being used as this irrebuttable presumption, an exclusive list and an irrebuttable presumption. So
Even if it wasn't,
I'm laying that card on the table.
isn't there the shifting burden? He has to show some
Yes.
evidence
Right.
that he lost the position due to his membership in the class.
Yes, and he has to,
Fundamental thing.
yes, and he has to provide evidence
And
at
what
this
evidence is there in
stage.
this record
There's none.
that the court had
There's none.
before.
At his deposition, he testified he was being treated differently because he was getting bigger files and fewer files. But that begs the question, fewer than whom?
Right.
Bigger than whom? And when I asked him that question, he doesn't know. He admitted, I have no idea what any of the other consultants were doing. Dr. Griffith, his one witness, said the same thing. She has no idea what Dr. Sampat was doing. So there's no admissible evidence before this court. And again, this is motion for summary judgment. This isn't motion to dismiss. Plaintiff needs to provide admissible evidence. And there simply isn't any. And if I could quickly address the Christopher,
Uh-huh,
He didn't appeal that.
right.
It's not in the notice of appeal.
Right.
And there's no reference to it. The notice of appeal is very specific. It deals with Judge Beffert's order only. Doesn't mention anything having to do with Judge Christopher. There's no general language about.
And you raised this in your.
Yes, yes. So we submit, this court doesn't have jurisdiction to consider that order. Thank you.
Mhm, thank you.
Mr. Flores?
To answer the question, on the record, in the record on appeal at page 189 is where the affidavit of Ms. Stone references that the position was filled in August of 2022.
Oh, okay, it was.
And to address counsel's argument that my argument here today was raised for the first time here about the position, not
they
filling
get
the
delayed.
position would be delayed. That's on page 26 of my brief where I
Okay.
directly erase and assert that that's an argument before this court. With regard to Dr. Griffin's testimony, Dr. Griffin, in the text messages that were referenced in a part of the record on appeal, without suggestion by Dr. Sampat in the course of their discussions, stated, I remember before you left that they weren't sending you certain types of cases, supportive of disparity in treatment between Dr. Sampat and other physicians, that she remembered without prompting by Dr. Sampat. And these are questions that I'm not asking the court to accept as gospel truth, but that raise material issues of fact as to whether or not my client should have been allowed to proceed forward with his claim of discrimination. To say that there was no evidence of any disparate treatment, while Dr. Sampat could not identify a specific doctor who was treated differently, he did say that his terms and conditions, and it's in the brief and it's in the record on appeal, were changed. They were different than under Joshanna Stone than they were before she took over. And that's, those facts are set forth in my brief beginning on page 9, where she reduced the number of cases that he was allowed to work on, where she affected his ability to earn the same wages, assigned him large charts for review, and even gave one example of where he did on October 29th of 2019, get assigned one of these quick review cases, and then he went to open it in his queue and it disappeared. It went to somebody else. Not even allow him to return to work early when he got back from vacation in November of 19. All of these things led up to this termination. Beach does not apply here. Beach was a RIF case. It wasn't a straight termination case. Termination cases, like failure to hire cases, have a different standard than a reduction in force case.
Because in a RIF case, it would be very pertinent if they'd replace the person.
Yes.
Because they're saying, I'm letting you go because we don't have any more work. And then if I come back in, I'm undercutting that idea if I come back in and hire somebody in the position.
Correct.
So that's what makes, that's your argument that
The
that's
beach
what-
is, but for.
That factor is specific to a RIF case.
Yes.
Okay.
And that.
At least, maybe all of them, but at least that one.
At least that one, yes. I don't know if I could go all the way with you there, but yeah, I
Okay.
would like to. I would like to.
You'll go with me one step at
Yes.
least.
And so, thank you.
Thank you. Break or keep
Don't
going?
mind. Okay.
We're gonna take a break of about 10 minutes now. We'll be back in, I'll tell you what, at 10:25.
So the attorney for Collins is here, right? Okay, all right.